Well, now to the trial in Charleston, South Carolina, of police officer Michael Slager. It's where a jury appears to be having trouble in coming to a decision. They need to make a unanimous decision on this verdict. And on the phone to discuss the case is CBS News legal analyst Rikki Klieman. Rikki, the jury has now entered its third day of deliberations. These cases are so tough when it's a police officer versus someone who's been killed. We've seen in these cases often they side with law enforcement. There's just some protections that are given to law enforcement. Why has it been a bit longer with this case?
Well, I think that one of the things we don't yet know, which would tell us a great deal more, Reena, is the inability to come to a verdict. Is it one person? Is it more than one person? If it's 11 to 1, is it 11 to 1 for conviction, or is it 11 to 1 for acquittal? We may or may not know those answers, but I can tell you one thing. In a case like this, if they cannot come to a verdict, you can bet your bottom dollar that the prosecutor will retry Officer Slager.
So even if this is a hung jury and they don't have a verdict, you think that they could still come back again?
No, I think that what happens is if there's a hung jury and the jurors are absolutely adamant that they cannot reach a verdict, the judge can only do one of two things. He can send them back out and say, try harder, and give them what we call a dynamite charge, which is to tell them that it's really their responsibility to come to a verdict, which often brings in a verdict. Or the judge can simply declare a mistrial. If there is no final verdict and a mistrial is declared, that jury is discharged. They go home.
And
then the prosecution can and undoubtedly will try Officer Slager again with a new jury.
I see. Got it. Okay. Rikki, we know that last night the jury sent a question to the court asking for the difference between passion and fear. Why would they ask a question like this? Where do you think they're heading with the thinking here?
Well, I think that one or more of the jurors is concerned about the issue of fear in self-defense, or could be confusing the issue of fear with heat of passion, which is the definition of manslaughter, which is a much lesser included offense in South Carolina. Manslaughter is a 2-year to 30-year penalty. Murder is a 30-year to life penalty. That's a big difference. So you could have someone who is adhering to the belief that the officer really was in fear, and perhaps that equals heat of passion, or it is complete self-defense if the fear is reasonable. We don't know, and we may never know. But the concepts of heat of passion and fear often seem to kind of piggyback on each other. So the jurors wanted some clarity. The judge was not willing to give them any more clarity at that time and told them to use their common sense.
And this is something common, Rikki, that judges do, just not to interfere and taint the case in one way or another?
I think that it is common for a judge not to answer a common sense question. If they came back and said, could you read or could you give us again the legal instruction for manslaughter, that I think the judge may have done that. But this was actually looking at two concepts where the judge himself was at a point of just saying, you know, if I talk about it, I'm really at a point that they might think I have an opinion, and I don't want them to think I have an opinion. So there are many questions jurors ask that judges will not answer.
Rikki, I want to play just a short time ago, minutes ago, the judge weighed in and had something to say. I want to play back that audio. It just happened a short time ago, so you can hear exactly what the judge had to say.
Ladies and gentlemen, you've stated that you've been unable to reach a verdict in this case. As I instructed you earlier, the verdict of the jury must be unanimous. Now, when a matter is in dispute, it isn't always easy for even two people to agree. So when 12 people must agree, it becomes even more difficult. In most cases, absolute certainty cannot be reached or expected. However, you have a duty. You have a duty to make every reasonable effort to reach a unanimous verdict. In doing so, you should consult with one another, express your own views, and listen to the opinions of your fellow jurors. Tell each other how you feel and why you feel that way. Discuss your differences with an open mind. Although the verdict of the jury must be unanimous, every one of you has the right to your own opinion. The verdict you agree to must be your own verdict, the result of your own convictions, and you should not give up your firmly held beliefs merely to be in agreement with your fellow jurors. The majority should consider the minority's position, and the minority should consider the majority's position. You should carefully consider and respect the opinions of each other and reevaluate your position for reasonableness, correctness, and impartiality. You must lay aside all outside matters and re-examine the questions before you based on the law and the evidence in this case. If you do not agree on a verdict, I must declare a mistrial. In that case, it does not mean that anybody wins. It just means that at some future time, I will try this case with some other jury sitting where you now sit. The same participants will come, and the same lawyers will likely ask basically the same questions and get basically the same answers. And we will go through this whole process again. You were selected in the same manner and from the same source any future jury will be. And there's no reason for me to suppose that the case will ever be submitted to 12 more intelligent, conscientious, and competent jurors than you, or that more clearer evidence will be produced on one side or the other. I therefore ask that you return to your deliberations, if you will.
You heard the judge right there, Rikki. Why is it so important and required that they reach a unanimous decision and not majority wins on this one?
Well, two reasons. Number one is that in criminal cases, a unanimous verdict is required in almost all jurisdictions. And it's part of the reason that the burden of proof is so high, of proof beyond a reasonable doubt. Not proof beyond all doubt, but proof beyond a reasonable doubt. And secondly, that in places like where we are now in South Carolina, it is mandated and constitutionally required. So what we have here and what you've just heard is a perfect example in a very calm, controlled tone of what we call the dynamite charge, or in my day of practicing, it was called the Allen charge, named after a case. And what that is saying is that, look, there is no jury who is going to sit in this box who's going to be any more qualified than you are. And if we have to do all this again, and we have to, without saying it, spend all of this time and money in doing this again, so that is not said, but it's what's implied, we're going to get the same questions and the same answers. So I'm asking you, the judge says, to reconsider and try to reach a consensus. Of course, in the dynamite charge, or the Allen charge, it is balanced with the language of saying, you know, if you have a firm conviction of your own belief, that your belief is correct and it's not the majority's, of course you can hold on to it. But it's one of the things we do in juries. We take what we call secondary groups, groups of strangers, and make them become a primary group by reaching consensus. And almost inevitably, jurors do reach a consensus. What will happen now is it's 2:28 Eastern Time. The judge may keep them until about 5 o'clock, would be my supposition, and see if they reach a verdict before then. He may make a choice to have them go home over the weekend and let their minds cool and try again on Monday morning. Or he may say at the end of a few hours, if they cannot reach a verdict, okay, then we'll have a mistrial. But that was, I have to say, one of the best examples I've ever heard of an Allen charge or a dynamite charge. It was really well done.
Rikki, I want you, if you can hang with us for just a second, I want to bring in our David Begnaud. He was inside of the courtroom. David, what can you tell us? And is there any sense of how long this jury will continue deliberating?
No, I can tell you from a couple of political observers and judicial observers here near the courthouse, they are of the thought that the judge is not going to just declare a mistrial easily. In fact, we were talking to one attorney who said, I wouldn't be surprised if the judge considered putting them up in a hotel tonight, having them continue to go on, or waited well into next week, kept telling them, go back, you guys need to come up to a unanimous verdict. He did, in instructing them, read from what appeared to be a previous assembled note, if you will, and said to them, you guys have a responsibility to reach a unanimous verdict. It is your duty. And I noticed at one point, Reena, when the jury initially came back and the judge read the note that they had sent him, which was, we don't think we can reach a unanimous verdict, at one point the judge said aloud in the courtroom, is it worth going back? Do you guys think you can reach a verdict if I were to send you back? And a couple of the jurors leaned forward, and I saw them looking at each other, shaking their head like, no, I don't think that's going to work. And the judge said, wait a minute, don't answer that. Go back and then send me a note and let me know if you will be able to do it. So at any rate, he sent them back. They are upstairs on the 4th floor right now, deliberating again. It's hard to tell. He did tell them, look, if I declare a mistrial, the jury that's going to come back is going to hear everything you heard. They're going to be just as smart as you, just as judicious as you will be, but essentially saying to them, look, give it a go again. And I saw one woman in the very back, Reena, and she was listening intently to the judge, and she appeared almost emotional. And at one point when the judge said, so I'm sending you back to deliberate again, she started nodding like yes, almost as if she was in agreement. Some of the other jurors in the box appeared emotionless almost, just listening to the judge. Nobody seemed frustrated that they had to go back, but this again is the first time they have come to the judge and said, we don't think we can reach a unanimous verdict. And the judge has said, you got to go back at it.
It's a hard time for these jurors. They've been at this for quite some time now, 3 days deliberating. Now, David, while you're in the courtroom, you're not actually in, obviously, the deliberation room with these jurors. But tell me, what has struck you so far in this case, and why do you think, I'm asking you to speculate a bit here, why do you think it's taking them such a long time, despite all the evidence being laid out here?
Well, that's a good question. I wish I was in there. But in a case like this, you have what prosecutors have said. It doesn't happen very often. You have a video showing a man running away from a police officer and a police officer firing at the man who, according to all estimates from investigators, was at least 17 feet away with his back turned toward the officer when the officer opened fire. So for a lot of people who've watched this, they've said it's pretty clear cut. And how could this guy get away with it? Not my words, but the words of observers who have come and listened to testimony. But at the same time, Reena, when you start reading the sheets and when you realize what the options are, they can either convict him of murder or voluntary manslaughter, or they can say he's not guilty, or they can decide that they can't come up with a unanimous verdict, and so it's a hung jury. Right. I think what we're seeing and what some observers are now opining is that it's perhaps not as clear cut to the jury as it is to the members of the public. Remember, as much as we, the members of the public, might want to sit here around the coffee table and say, can you believe that video is pretty clear cut, seems easy to me, these jurors have listened to every single word over a long period of time. They're making beans to sit there. It is their duty and their civic obligation. So we have to give them the credit and say, if they're having a rough time with it, maybe there's more that they know that maybe the general public does not know. It's also worth pointing out, Reena, it's kind of interesting. Right across the street from where we are, there is an incredibly heavy police presence. That's where the Dillon Roof jury selection is ongoing. So you have two big trials in South Carolina, jury issues happening at the same time right now, right across the street. So a lot of eyes right now on the courthouse. But we'll keep you updated. The judge just sent him back, and he doesn't appear ready to send him home anytime soon.
Fascinating details from inside and outside the courtroom. David Begnaud and Rikki Klieman, I'm sorry, we're going to have to leave it there. We've got some other news to get to. Thank you both.